It's now time for Constitutionally Speaking. And of course, this is all courtesy of our friends at the Office of the Public Defender. The Deputy Public Defender will join me momentarily. But let me tell you that today's topic is the Sexual Harassment Tribunal. Do remember that last week the government, through the Minister of Culture, Gender, Entertainment and Sports, Babsy Grange, announced the first Sexual Harassment Tribunal since the coming into force of the Sexual Harassment Protection and Prevention Act of 2021 nearly 4 years ago. We have to dissect this new Sexual Harassment Tribunal, looking at it, its role, its composition, the powers of the tribunal, and even how complaints are made to the tribunal. All of that coming up in this segment as we say good morning and welcome to our expert, legal expert, with all the information that we need. Good morning, Deputy Public Defender Herbert McKenzie. How are you doing this morning, Mr. Mack?
Good morning, sir. I'm fine. Thank you, and I trust all is well with you too.
All is well with me, indeed. I thank you for joining me once again. The listeners are waiting on you, and they're hyped and ready to get the information that you have to share. So take it away.
Yes, this morning we've been looking at the Sexual Harassment Tribunal. The Sexual Harassment Tribunal is that body which is formed by virtue of the Sexual Harassment Act. That sexual harassment law was made to protect and prevent, as the name implies, the sexual harassment at the workplace. But it actually goes beyond the workplace. Anywhere people are gathered for a particular purpose, a special unique purpose, then sexual harassment can occur, and the law seeks to protect and prevent it. So if it's in the church, if it's in the prison, if it's at a club, if it's at the marketplace, at a shop where people are gathered, then sexual harassment is a possible feature which the law seeks to prevent and to protect people against. And when we speak about protection, the law is not gender specific because the law regards sexual harasser, for want of a better word, possibly be a female as well. So it works both ways. So it's a big law, and at some stage we'll go through it. But for the purpose of the newly appointed tribunal, we're going to stick with its role and what it does. Now, the role of the tribunal is to hear and determine complaints, and to make awards for compensation or orders based upon the complaint that is received. Now, before we go further into that, let me just say what the tribunal is comprised.
Yes, okay.
Now, under the law, it must be 14 members appointed by the minister. In this case, the minister under whose responsibility that falls is the Minister of Gender, Culture, Entertainment and Sports, that's Mrs. Grange. And the 14 members must include at least 4 attorneys at law. Each must have at least 10 years of practice. 4 certified mediators, trained and certified, at least 2 years of practice. So that's 4 and 4, 8. And the other 6 shall be persons qualified in matters of work representation, trade unionism, gender affairs, mental health, employee representation, and labor relations. So that's 4 and 4 and 6, 14 persons. And the tribunal must have a chairman, and its minister who appointed the chairman, and must have also 2 deputy chairpersons. In this case, the chairman is retired Court of Appeal Judge, Mr. Justice Ferdinand Algernon Smith. He's going to be the chairman. Well, he is the chairman, though. Now, although there are 14 members, in hearing and determining complaints, the tribunal select a panel of 3 from its members, and that panel must include both genders. So you could have 3 to 14, 3 fours, 4 panel going on at any one time, provided they have the facility and they have the physical plant to do it. Now, a complaint to the tribunal must be made within 6 years of the date of the incident, or if it's a continuing thing, at least or within 6 years from the last date of the occurrence. And that applies for cases where the complaint is being heard for the first time. Now, it's slightly different when the complaint is not being heard for the first time. And let me explain a situation. No. The tribunal was set up to hear appeal from sexual harassment complaint. But guess what? A person who feels sexual harassment doesn't have to go through the regular process. The person can bypass all the mechanism at his or her workplace and go straight to the appeals tribunal. And in that case, if you're going straight to the appeal tribunal, it must be made within 6 years from the date of the incident, which you, the complainant, would regard as sexual harassment. So, now that takes me back to the other things that the tribunal or other matters that the tribunal can hear and determine. Because, like I say, it doesn't have to be the first hearing or the first complaint.
Mm-hmm.
The tribunal can hear and determine complaints made against an employer or head of institution alleging that he or she has disclosed unauthorized information relating to the complaint. So in other words, the complaint that is made must be private and confidential. If the person makes it to the boss is under legal duty not to disclose it unnecessarily. Of course, he's under obligation to inform the potential harasser as to the complaint against him or her.
As you mentioned the word complaint, Mr. McKenzie, I'm just wondering here, what have been, has it been challenging getting people to come forward, victims to come forward and utilize the tribunal's processes in terms of persons' reluctance to make these kinds of reports?
The law is in its infancy. We haven't seen a lot yet. Mm-hmm. The thing about it, though, why that we're not seeing it isn't an index of whether or not people is using it. It's simply because it's internal. And when we go through the action in a subsequent program, yes, I'll explain the internalness, for want of a better word. Because let me say it here that the Sexual Harassment Act is not a criminal statute. The act of sexual harassment is not regarded as a crime. So the act puts certain mechanisms in place, and it's largely internal. And if it is settled internal, usually the victim or the complainant either accept the settlement that was settled or simply leave the workplace and move on. Oh. Need to be said, though, that if anybody disagree with the Sexual Appeals Tribunal ruling, whether or not it came there first and it came by way of appeal from something that the employer or the other position did not do, then the person who was aggrieved by the tribunal's decision can take it to the Supreme Court or the Supreme Court to review the tribunal decision. What all that says is that the Sexual Appeal Tribunal is exercising quasi-judicial functions. Now, the other areas which the Sexual Appeal Tribunal can hear cases from are cases where the employer is, based upon the allegation of the complaint, failed to act upon his or her report of the harassment, or the employer has failed to act upon it within the specified time, or it is the head of the organization itself who is sexually harassing the complainant. Then you can't appeal to Caesar against Caesar.
Right. You
have to go straight to the Sexual Appeal Tribunal. Or if it's a case in which the person, who though might not necessarily be the head of the organization, exercised authority over the victim. Or in a case where the victim is seeking to be admitted to an organization to join it, this government organization, the person who has the final decision as to that person's admission is the harasser. Complainant cannot go to him or her. In that case, the complainant goes straight to Sexual Appeal Tribunal. Now, what can the Sexual Appeal Tribunal do in the case of a complaint before it? The Sexual Appeal Tribunal has powers to, it might sound harsh, listen to the complainant. Whether they come directly as an appeal from the complainant not having had what he or she regards as justice from the employer at the head of the institution, or whether the complainant came directly to the appeal tribunal from the complainant who bypassed everybody. So the tribunal can dismiss the complaint. Or tribunal can rule in favor of the complainant and determine a number of things. First of all, it can say that I can find that the person against whom the complaint is made was actually culpable, and he can reprimand that person and make an order that it not be repeated with consequences if it is repeated. Mm-hmm. He can also, the Sexual Appeal Tribunal can also award monetary compensation to the complainant, or can order that the person found liable for the sexual harassment perform any reasonable act or conduct to redress any loss or damage suffered by the complainant. And I suppose one of the ones that you may find people talking about cases where females find themselves being deprived of promotion because they probably didn't give them to the advances or the courtesies that sought to be extended by the head honcho. In that case, we could envisage a tribunal saying, look, based upon all that we have, the promotion is because this person has rejected your advances sexually. He or she is entitled to the promotion.
Yes.
And like I say, it could be monetary compensation to the complainant. However, in such cases, the compensation cannot exceed $900,000 in Jamaican currency. So it has a cap and a jurisdiction. The tribunal can also order that the person who is found culpable for harassment take certain action within a specified time to ensure or to put measures in place that this does not happen again, or this does not happen to this particular individual. Similarly, the person against whom the award or the order is made can also go to the Supreme Court for redress if they think the Sexual Appeal Tribunal is against them. Now, I said earlier on that the complaint coming to the tribunal must be made within 6 years. Mm-hmm. And that is if it's coming for the first time. If it's a complaint not coming for the first time, in other words, a complaint in which the victim is not satisfied with the outcome of her complaint at the organizational level, i.e. at the workplace, at the head of the organization, or in the authority in which she is, the person who's in charge of him or her. If that victim or that complainant is not satisfied with the outcome, then the victim or the complainant must get to the tribunal within 1 year to complainant. See the distinction?
Yes.
If you're coming for the first time, you have to come within 6 years.
6 years, yes.
If you're coming by way of not being satisfied with what happens at the workplace, where you made the workplace, the top man or the top one who hasn't handled it properly, or even they might have handled it properly, you think the decision is not what you expect it to be, then you have 1 year, within which to bring it to the Sexual Appeals Tribunal.
Noted.
Now, before we run off, I just want to say one thing, and it's repetitive. Sexual harassment, now as it stands, under the sexual harassment law, is not a criminal offense. That doesn't mean that under the Sexual Harassment Act, crimes cannot be committed. So, for example, if under the Sexual Harassment Act, somebody does something to a victim to prevent him or her from reporting it, harm the victim, try to harm the victim, or if somebody who is supposed to not disclose information, then those things are contained within themselves, prosecutable before a court of law. But the act of the sexual harassment itself, as the law stands now, is not a criminal offense. Mm-hmm. Time upon us.
Before you go though, yes. I mean, outside of programs like these, are you satisfied that enough measures are being taken to increase public awareness and confidence in the tribunal, especially among vulnerable groups, domestic workers, young employees in the informal sector, and so on? Or should more be done in terms of public awareness?
let me answer the question this way. When the law just came out, the ministry with portfolio responsibility for it did quite a bit in making public education. But I think with time, that has lapsed, and we find, when I say we, we are the Office of Public Defender, but there are still a number of people who seem not to be aware of the existence of the Act. And in equal measure, those who are aware, a lot of them think that sexual harassment is a crime. And you hear them talking about going to the police to report the man because the man did this to her, said that to her. So, in short, more can be done. It is not that I think anybody, any ministry of the department is neglectful. Mm-hmm. I think it's just a matter of the whole society and the organs of society being overtaken by other things, like, for example, crime, salary and wages, and the general hardship that we experience day to day as Jamaicans in this little country.
Mm-hmm. Mr. McKenzie, thank you so much for the information you shared with us this morning on the Sexual Harassment Tribunal. Thank you so much and have a good day. Catch you again next week.
Thank you, sir.